And the final case on our docket is Kenneth B. Wheeler versus Albert Powers et al. Wish to reserve any time, sir?
Yes, Your Honor, 5 minutes, please, for rebuttal. May it please the Court, my name is Alex Douglas. I'm with Poland Short in Winter Park, and we represent Kenneth Wheeler, who is a practicing lawyer, state planner lawyer in Winter Park as well. The issue in this case is whether or not Mr. Wheeler, as a co-trustee of a trust and as alternate personal representative of Dorothy Powers' estate, has standing to bring a counterpetition to revoke probate. The facts in this case, Your Honor, I think are very pertinent to this issue of standing. And the trial court had dismissed the counterpetition. And with regard to the facts that have been alleged in the counterpetition, of course, on a motion to dismiss, those facts have to be taken as true. In 2000, Mr. Wheeler had an attorney-client relationship with...
Counsel, we're familiar with the facts in the case, and we've read the briefs and all, so why don't you just tell us why you think an alternate personal representative under prior will has standing?
Yes, Your Honor, I think there's three reasons. The first is that Mr. Wheeler had filed a caveat as an interested person. And under the probate rules, he's allowed to do that as an interested party. The clerk of the probate court did not give him notice with regard to the admission of the probate proceedings with regard to the admission of the 2005 will. Notice was given to Mr. Wheeler later, and then he timely filed his counterpetition. Because he has standing as a caveator, he must be given notice before the order admitting the will into probate. Case law is clear that if the caveator is not given notice, then the order should be set aside, and the caveator should be given a right to present his case before that issue is decided. So the first basis is because he's a caveator. Now, I do point out, Your Honor, that I think that the standard with regard to standing to file a notice of caveat should be read broader than perhaps standing with regard to the right to bring a claim in the court. And the reason why I say that, Your Honor, is both issues are governed by what is an interested party. But the statute that's determinative here with regard to the issue of standing, 731-201-21, by the very language in the statute, the legislature has given some liberal terms in the definition of standing that allows the probate court essentially on a case-by-case basis.
How can Mr. Wheeler be affected by the outcome of this particular proceeding?
He can be affected, Your Honor, because under the 2001 estate planning document, he was named as co-trustee of Dorothy Powers Trust and as alternate personal representative. We have alleged sufficient ultimate facts to show that that the later will and the later amendment to the trust was procured either by undue influence by a previously disinherited son or was done at a time where Dorothy Powers lacked testamentary capacity. She was Baker Acted 2 weeks after that January will was signed. Because we have alleged sufficient ultimate facts to show why the 2005 document should be set aside, that puts squarely in place the 2001 estate planning documents. The sole beneficiary of Dorothy Powers' estate is her trust. Mr. Wheeler, as co-trustee, is a beneficiary, not in his individual capacity, but in his fiduciary capacity. Clearly, under the standing statute, a beneficiary of the estate has standing to bring a will contest. We have also alleged that Albert Powers is either unfit or unable to perform his duties as personal representative. Again, we have alleged sufficient ultimate facts to put at issue the reason why Mr. Wheeler should have priority as personal representative. If we are successful and allowed to show our evidence and to show and to prove what we have alleged, then we certainly, Mr. Wheeler will certainly be the personal representative. The problem here, Your Honor, is that we've been cut off at the knees before we even have had an opportunity to present our evidence. And we have, because we have alleged in good faith sufficient ultimate facts, that is enough, Your Honor, to show under the standing statute why we have an interest here. Mr. Wheeler is not just a person that is unconnected with Dorothy Powers. He was named named in our previous testamentary documents as a fiduciary. That gives him standing, not only with regard to his position as alternate personal representative, but with regard to being named co-trustee, both of which...
Are you asking us to rewrite the statute where the legislature specifically indicated the class of people that they would want to have? They named a personal representative, could not, if they had intended to include someone else, also written in the statute alternate personal representative, but they chose not to do that.
No, Your Honor, I'm not asking that you rewrite the statute. And the reason why is that the statute itself is liberally written to give flexibility for the court on a case-by-case analysis to determine who is an interested person. The statute does say that a personal representative has standing. The statute does say that a trustee has standing. Now, the Engelberg case that we have cited held that a personal representative named in a previous will has standing to contest a later omitted will. There is no logical difference that I contend between a personal representative named in a will and an alternate personal representative, so long as the person coming to court can allege sufficient ultimate facts to show why he should serve as personal representative. If we did not have those facts to allege, then we would not have standing. The statute, Your Honor, says personal representative. It doesn't specifically say personal representative named in a previous will. However, the 4th District in this state has ruled, as well as the Hopkins case early on, Hopkins versus McClure, that a previously named personal representative does have standing. And I submit there is no difference between a previously named personal representative and a previously named alternate personal representative, provided the pleader coming to the court can allege those sufficient ultimate facts to show why the first named person should not serve. The ultimate facts in this case, Your Honor, that have been alleged are important because we have alleged that Albert Powers was living or was living at the time with Brian Powers, the son that was disinherited. In fact, Dorothy was apparently moved up to Minnesota where Brian Powers lived before she died. So there are certainly facts here that would support why Mr. Powers should not serve as personal representative, in addition to the fact that he did sign a paper that was filed with the court that said that he was unable due to health reasons to serve as Dorothy's attorney in fact, which then allowed Brian Powers to serve as her attorney in fact. So there's ample facts here that we have alleged that would show why Mr. Powers, as alternate personal representative, should serve in her estate as the personal representative. The recent case I want to point out to you, Your Honor, of the Florida Supreme Court in Hayes versus Guardianship of Mae Thompson, I think is especially helpful with regard to the issue of standing. The Supreme Court recently said that we're not going to have a bright line test. The court rejected any kind of bright line test. Instead, it says you have to look on a case-by-case basis with regard to the circumstances as to whether they're standing. And just like the first sentence of the statute says. And so saying that, though, the court did say that where a person has a right, either by statute or probate rule, to receive notice of a proceeding, that should be enough to show that they have standing. And I go back now to the fact that Mr. Wheeler filed a caveat in this case. He was entitled to file a caveat under the fact that he was named as co-trustee and alternate personal representative. He was entitled to receive notice. That should be enough, Your Honor, to show standing in this case, especially given the comments of the Florida Supreme Court on this issue. The fact that the Supreme Court has rejected any bright-line test, I think would also, Judge Perry, would also go to your question. Well, the statute doesn't specifically say alternative personal representative. Okay. However, the statute does have that, does define someone with standing as any person who may reasonably be expected to be affected by the outcome of the particular proceeding involved. Certainly, a person who is co-trustee of a trust that is the sole beneficiary of a estate would be affected by a probate proceeding with regard to which will should be admissible for probate. Certainly this would not open up a Pandora's box as the appellee has suggested in the briefs. And the reason being is that you still have to have the facts to back up why you have standing. And there are, of course, sanctions that we have under 57-105 for someone coming in with a case that has no facts to support it. So there's not going to be a parade of horribles here, because if someone was an alternate personal representative, for instance, and had no basis to claim why the first named person should not serve, that person's claim would be baseless. And this should not be a concern because of 57-105 and the other rules and statutes that we have with regard to bringing baseless claims. Again, Mr. Wheeler has alleged facts in good faith here that support his position and standing in this matter. For these reasons, Your Honor, I would ask that the court overturn the order dismissing Mr. Wheeler's petition, and I would like to reserve the remainder of my time for rebuttal. Thank you.
Thank you.
May it please the court, I'm Don Hawkins. I'm here with my partner, Mr. Burt, and we represent Albert Powers individually and as personal representative of the estate of his deceased wife, Dorothy. I have no great quarrel with the central issue of what the appellant is seeking here, and that is that this is a standing case, pure and simple, and that this standing determination must be made based on whether or not the appellant is an interested person. It's interesting to look at some of the factual situations here, that this is a personal representative that is not named primarily but named alternately by the decedent in a will twice removed from the will that's being probated. He was the drafting attorney of that same will for the decedent. The testator was unwavering.
Did it make any difference whether he was a co-trustee or alternate trustee, as long as he has?
Because we have the named personal representative serving and we have the co-trustee serving, and to fail to recognize that fact does violence to the intent of the testator. The testator obviously should have a right to select her primary personal representative and to rely upon that selection as a priority that would be respected by the courts. So my point is that the statutory interpretation of 731-201 as to whether or not the appellant is a defined interested person turns on that language. And the language contained within that paragraph is, in any proceeding affecting the estate or rights of the beneficiary in the estate, the personal representative of the estate shall be deemed to be an interested person. Now, I stop at this juncture because that is also a word of art defined in the same statute. Who is a personal representative? And the language of the statute goes on in 733-201 subparagraph 25 to say that a personal representative means the fiduciary appointed by the court. So my point here is that the defined term, interested person, limits it to the appointed personal representative, court appointed, not nominated by the decedent, but court appointed. So the appellant doesn't come here clothed with nomination by the court as an interested person. And that is a distinction that the appellant overlooks and glosses over. Interestingly, it's also a distinction that was not dealt with in the Engelberg case back in 1991 by the 4th District Court of Appeals. The point that Judge Perry raised, therefore, is that why should an alternate personal representative be included? And the answer is an alternate shouldn't be included. A nominated personal representative, one named in a will, also should not be included, acknowledging that Engelberg out of the 4th District finds differently on that point. This court does not need, however, to look simply at the prospect of disagreeing with Engelberg to support the trial court in the instant case. The trial court in the instant case found that an alternate named or nominated personal representative of a twice removed will isn't an interested person. We submit that was a correct finding, that indeed Mr. Wheeler, the author and nominated personal representative, the author and named personal representative in the 2001 will isn't an interested person as defined under the statute.
Does it matter whether it's twice removed?
No, I don't think so, Your Honor. I think that what it does when you start talking about twice removed and thrice removed is it simply points out to us as practitioners of probate law how there are many layers in testators' estate plannings. And the more you have, the more layers you have, the more subject you are to meritless litigation by virtue of older alternate fiduciaries coming in and trying to upset the current estate plan. And where it becomes significant is you don't have a true interested person. You don't have a person with a pecuniary interest. You don't have someone that has a true dog in the fight. There isn't an heir. There isn't a beneficiary. There isn't an interested party in this litigation. Mr. Wheeler is a lawyer without a client. He's a fiduciary without anybody he's representing coming before the trial court and saying my interests are at stake here. And that, I think, is very significant. And that's significant in response to whether you have multiple layers back in there that you deal with.
So if we merely had a situation, a simpler fact situation where you have the same setup as in 2001, where Wheeler is the personal representative and trustee, and then you have a subsequent will 6 months later in which other people are named.
The same rule would apply. Here we have a 2001 will, a 2004 will, and a 2005 will. But if we just had two wills virtually back to back, it would not make any difference where we have an alternate personal representative and no client coming in, no interested party. Your Honor, I think there's one fact situation that maybe it was dealt with in the briefs.
Well, let me just back up and make sure that I fully understand your position. So he would not be an interested person even if he were the named personal representative in the preceding will?
I say, Your Honor, that that's true under the strict interpretation of the statute because both subparagraph 21 and 25 read together say that a personal representative has to be an appointed fiduciary, not simply a named fiduciary.
Okay.
And I think that to read 731-201 sub 21 and ignore the paragraph, four paragraphs down, saying what a personal representative is, does violence to the intent of the statute and assumes that the legislature didn't know what they were doing when they wrote it.
Well, what that means then is that if you have a potential challenge to a will based on undue influence or whatever, then the personal representative under the prior will has no right, power, or interest to attempt to interfere with that subsequent will, even if he believes that it's completely invalid or void.
Absolutely. I think that's absolutely correct. And I don't think that does any violence to protecting the testator's scheme of things and protecting the rights of the parties, because if there were a client, if there were an interested party, a beneficiary under that earlier will, that beneficiary would have a right to come in and raise the very issues that Mr. Wheeler is attempting to raise as a mere nominated alternate fiduciary.
What about the fact that he is the trustee of the beneficiary trust?
He is not the trustee of the beneficiary trust. That
Alternate trustee.
No, Your Honor. He is the co-trustee of a prior version of the beneficiary trust. By the way, guess who he's the trustee with again, of course? He's the trustee with the surviving spouse.
Right.
So the testator always named her husband as the fiduciary. Well, I say always. Yes, the testator named her husband always as the fiduciary throughout, and only in the 2001 version did the testator allow Mr. Wheeler in as a co-trustee and an alternate fiduciary.
But for purposes of your argument, it really doesn't matter, does it?
I don't think it matters where there is not a true interested person here as defined by the statute. Yes, I agree.
Because as a co-trustee of the trust and as the personal representative designated in the prior will, he can't be an interested person.
He doesn't fit under the statutory definition. And of course, as a co-trustee, he doesn't have unilateral authority to bring the suit anyway. Even if we were to leap and make the assumption that he had some authority as co-trustee.
Why isn't he affected by the outcome of the particular proceeding? Because if the particular proceeding, say it's brought by a beneficiary, if the outcome of the particular proceeding is to undo the will, then he becomes the personal representative.
He does.
So, and if the outcome of the proceeding is that the subsequent will is not invalidated, then he is not the personal representative. Why doesn't that constitute being affected by the outcome of the particular proceeding?
I think affected by the outcome of the proceedings as read in the case law and read in the statute implies an effect that changes how things will happen to that person, to the beneficiary, in terms of heirship, beneficiaryship, that type of thing. I don't think it simply applies to whether someone serves as a fiduciary or not. And I think that that's consistent with the statutory language under 731-201 because that language talks about a personal representative very specifically and then goes on to define what a personal representative is. Does that answer your question, Judge Griffith?
Yes, sir, it does.
All right. So we've seen the distinction between appointed versus nominated personal representative and between an interested person who is an alternate or a primary. Again, this is a situation where the appellate asks that this court, first of all, follow Engelberg, which is something of a reach since Engelberg has ignored the plain meaning of the statute, I respectfully submit. But even if we say, okay, we're going to follow Engelberg, Engelberg is distinguishable because this is not the personal representative coming in seeking to serve under a prior will. This is the alternate coming in under a prior will. And the alternate is coming in the face of the fact that the named, nominated personal representative under the prior will, the one that takes precedence over him, over Mr. Wheeler, is serving and sitting and is presently available. So we've simply, by following the appellant's suggestion, allowed multiple fiduciaries under a prior will to come in and attack the sitting fiduciary under the current will. The appellant raised the capacity issue, and I need to address that, Your Honors. The appellant says that because he has well pled ultimate facts of capacity, that this court, the trial court, had to take that as fact and therefore entitles him to be an interested person. That's a reverse argument. That's raising by the bootstraps. Because when we look at the capacity issue, that's determined by another section of the statute, Chapter 733-506, and by another rule, Rule 5.440, both of which require, again, an interested person to be the one who raises the question of the capacity of a fiduciary. So it's circular reasoning. You can't say, gee, I'm going to allege the incapacity of the named personal representative so that I can become the successor personal representative, and I'm going to do it on the basis of well-pled facts of capacity. He doesn't meet the statutory and rule definition of one who can bring that action. The caveat issue is the same way. The caveat isn't keys to the courthouse for the appellant. The caveat has to meet the threshold requirement of interested person again, because that's right in Rule 5.260 sub A. Who can bring a caveat? It must be brought by any creditor. He's not a creditor. He acknowledged that at the trial level. Or an interested person. And again, he's not an interested person. He doesn't fall within that definition. So the threshold question was, did he get appropriate notice and due process on the issue of whether he had standing? He got that. He got a fair hearing on the issue of standing. It was determined he did not have standing, and it was determined that he was not an interested person who could file a caveat, so the caveat itself is a nullity from the outset. And Judge Griffith, I wanted to make one point that's sort of in response to what you said. That is, how are we going to determine whether someone really is going to be affected by this outcome? There was a person early on in this litigation who was affected by the outcome. That was a beneficiary named Richard Powers. The record reflects that. It's in the transcript at page 28 and in the record at pages 46 through 145, where Richard Powers, with an earlier attorney, brought an action here to determine which was the valid will of the decedent, and then dismissed that action right after that. Richard Powers was a true interested person. Richard Powers was accepted by the court to do exactly what the...
Didn't I see that there was a subsequent beneficiary that had commenced some proceeding or something, the Scottish Rite Temple or something?
You did, Your Honor, but that I don't think has any legal effect, because that was simply a notice of appearance by the attorney for the Scottish Rite Temple, and it was done after the trial court had finished its labors in this case. It was not done in any fashion that would be timely, so it would impact the trial court's determination or indeed this court's determination.
And as I understand your argument, it doesn't matter anyway, because Mr. Wheeler would not have he could not be heard whether someone else commenced the proceeding or whether he did it himself.
Mr. Wheeler could not be heard. Now, had Scottish Rite come in its own right early on in the proceedings, then my arguments would fail against them.
Right, but under no circumstances they fail under Wheeler, because no matter who commenced the proceeding, whether he did it himself or somebody else did it, Wheeler cannot be heard.
Exactly. That is the position that is the appellee's position. That's the position taken by the trial court, and that's a position that's consistent with the statutory and rule interpretation that was in here. As to the issue of capacity of my client, Albert, no allegation was made that he was unable to act as trustee, by the way. The only allegation that was leveled by the appellate at the trial was that he wasn't able to serve as the personal representative. Your Honor, what I would urge here is that this court, if it chooses to follow Engelberg, distinguish Engelberg in that it is a situation where an alternate nominated personal representative under a prior will is not authorized to bring an action and has no standing in probate proceedings such as this. Now, if the court agrees with me, obviously, that Engelberg inappropriately interprets the statute, then that raises another question. I candidly prefer the prior solution just due to cost savings on behalf of this estate, which has been pending a long time. But I would urge that the court not expand Engelberg under any circumstances, because that does allow interlopers such as Mr. Wheeler, to come into a case, to interject himself into an estate proceedings where he doesn't have a client, where he doesn't represent a true interested party, and to do so would allow us to, counsel indicated I used the term Pandora's box earlier, and I use it again today. I think that is opening Pandora's box to estate and probate litigation. We don't see it much. We haven't seen cases like this. Engelberg was decided in '91, and I think the reason we don't is that there are few who have the temerity of Mr. Wheeler with no client with a monetary interest to come in here and do what he's done. And so I suggest that this court not support that type of activity. I don't think it does service to probate administration throughout Florida. Thank you.
Thank you, counsel.
If you accept the appellee's argument, then this court would essentially be in conflict with the Engelberg case and in conflict with the Hopkins versus McClure case, which is the Florida Supreme Court from 1950. And I think Judge Griffin's questions are precisely on point with regard to this issue. And with regard to Appley's argument. His argument essentially is that you're not a personal representative until the court says you're a personal representative. Well, that's kind of a circular argument, because what we're trying to determine here is what is the true intent of Dorothy Powers, and whether or not that the will that has been submitted to probate is truly her testamentary intent. We submit it's not. The only possible way we can get that issue before the court is to have the court determine whether or not the 2005 will was procured by undue influence. If the legislature has determined that a personal representative has standing to bring a will contest or to be heard in a probate proceeding, and if the 4th DCA has likewise said that a previously named personal representative has that standing, then we believe there's really no difference between that and an alternate personal representative, so long as the pleader has alleged the sufficient facts to show why they should get priority, which we have done in this case. And I believe, Judge Griffin, your example that you were asking about would be one of like this. If you had a decedent who left all her money to charity and disinherited her sole heir, named a personal representative who was not the sole heir, and that sole heir procured a will essentially leaving it all to the heir, not to the charity, then the only way that the testator's intent would be fulfilled is if that named personal representative came into the court and said, Your Honor, the will that has been submitted for probate by the heir has been procured by undue influence and should be set aside. And that's exactly the scenario that would happen if the court adopts the appellee's argument here. And certainly, Your Honor, you make it the point that the Scottish Rite has filed a notice of appearance. They didn't receive notice of the 2005 probate. And they would only receive notice, Your Honor, I submit that if the 2001 will and trust are submitted for probate, because they are, of course, the beneficiary under the trust. And so the scenario I think you're asking about, Judge Griffin, is precisely the reason why this court should not adopt Appley's position to narrowly and restrictively interpret the standing statute. Because in those instances, Your Honor, there are several circumstances, in addition to the one I just gave you, where the testator's intent would not be fulfilled if we prevented an alternative named personal representative or a previous named personal representative from getting into the courthouse. The guiding principle of wills is to do what the testator wanted to happen to their property. It's not the heirs to decide that. It was the testator to decide that. And the probate court has the responsibility to determine the true intent. And this is what Mr. Wheeler is trying to do. Now, Mr. Wheeler the argument is that he doesn't have a client. Well, he is the client because he is the named fiduciary. And we have put at issue Mr. Powers' ability to serve as a fiduciary. Under the 2001 estate planning documents, if Mr. Powers is unable to serve as co-trustee, the document specifically states that Mr. Wheeler shall serve as sole trustee. Mr. Wheeler is the client. He is the fiduciary. He is the sole heir. And he should be given the right to present the evidence to the court so that the true intent of Dorothy Powers can be fulfilled. And for those reasons, I respectfully request the court to reverse the trial court order dismissing his petition.
Thank you, counsel. That concludes our session of oral arguments. The court will be adjourned.